All right, do we have our clerk?
Hear me, man?
Right, are you Mr. Brown?
Yes, ma'am. Can you hear me? Yes.
Okay.
Can you hear me okay?
Yes, I can hear you.
Thank you.
And Mr. Brown, from your end, are you guys ready?
Not sure why the video.
All right, just let us know when you're ready, Mr. Brown. And Miss Paul, you were on video. You're no longer on video. Are you there?
Apologies, Judge. I believe we're having some technical difficulties with the video.
I think we lost petitioner, so I think they're going to join back on here. Ms. Burke, can I make sure I can hear you?
Yes, I'm here.
All right, thank you. Is it Mr. Simons?
Yes, it's focus on it.
Okay, thank you.
Judge, we're ready on our end.
Okay, thank you. We're just waiting for petitioner to get back on. They were here earlier.
While we're waiting, could I ask if there's an exhibit to be displayed? Will that be done by the Division 5 clerk, Mr. Brown, or is that pulled on each party's computer?
I would say it'd be pulled on each party's computer. Everyone has access to the exhibits. So,
Okay.
all right, thank you. What's happening here? Okay, I think we're back. Is everyone here?
Question is, can we be heard, Your Honor?
Yes, thank you. Sorry, I think we lost you and you came back. All right. I think we're ready.
It was echoing, so it was in double when I spoke. So I thought, maybe sometimes it'll open in two different apps at the same time, Judge. So I just wanted to make sure that I didn't have constant double.
Appreciate that. All right. Mr. Brown, I think we're all ready to go on the record. And Mr. Brown, if you could let us know once the recording is on.
Oh, sure, it is on. Yes, ma'am.
Okay, all right, thank you. We're on the record in DO 2009-0139, Rodrigo Contreras versus Nancy Burke. Can counsel and parties please announce with the record, starting with the petitioner?
Good morning, Your Honor. Danette Paul appearing on behalf of the petitioner Roger Contreras, who's present and seated to my right. We are both appearing this morning via Zoom. All right, thank you.
Nancy Burke appearing pro se.
Thank you.
And this is Volker Simons, Assistant Attorney General, representing the Division of Child Support Services.
All right, thank you, everybody. All right, folks, my name is Judge Knapster. I'll be handling the proceedings today. We're here for two matters regarding Ms. Burke's motion that she filed back on December 31st, 25, regarding enforcement/modification of child support, and also petitioner's response/motion to quash. That was filed on January 20th, 2026. Before we move forward here, let me have the parties please raise their right hand so they can be sworn in by our clerk.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth during this proceeding, so help you God, or so you do affirm?
I do.
Yes.
All right, thank you both. You can put your hands down. All right. So I have considered the file, most everything related to child support, and of course the most latest pleadings, as well as the latest orders regarding child support, any prior child support orders as well. I would like to narrow the issues before we start taking testimony and evidence today. There has been a request by Ms. Burke to consider retroactive child support modification. I have considered the arguments from the pleadings from both parties, as well as from the memorandum that the state filed last week. Pursuant to 25327C, court has ordered denying the request for retroactive child support 3 years from 2025. As this is not the first request for child support, that statute is meant to be for initiation of the case. There were prior child support orders in this case, and one currently in effect since 2022. Court finds it's not appropriate, and that statute is not applicable to our factual circumstance. Per the statute, when there's a modification request, court is to order starting from the filing date, the next month after the filing date. Since the filing date was December of 2025, court will be looking at any modification of child support moving forward starting January 1st, 2026. For those reasons, order denying the request for retroactive modification. All right. As I noted in one of the in-chambers orders that I sent out, I will be keeping time. Okay. Any of the parties like to make a quick opening statement to narrow the issues down for me, or I'm fine with waiving openings as well?
I would like to make an opening statement, Your Honor.
Okay.
Throughout these proceedings, the respondent has alleged that she is unable to work due to actions taken by my client. That is 100% factually inaccurate. The current status of the respondent's bar license is her long-term suspension is due solely to her conduct, and that being that she violated the gag and seal orders that are in effect in this case by filing 2 appendices with the Supreme Court that contained documents that were protected by the gag and seal orders that are in place in this matter. And the state bar found that it was an aggravating factor because the state bar actually moved to seal the first appendix that she filed. And then as soon as that motion was filed, the next day, she filed the same documents, again, not under seal. So her repeated violations of orders in this matter are what led to the suspension of her license, and she is solely responsible for that. As such, it is our position that not only should she be attributed the income that she should be able to earn for child support purposes, but we would also like to raise the fact that Ms. Burke has been receiving additional monies through a GoFundMe page, and she is also living rent-free in a home that is a 3,700 square foot, $900,000 home that she's been living in since at least January of 2025. And that regularly recurring gift should be attributable as income to the respondent in this matter. And in the ruling, the court says that disciplinary courts have affirmed concept that frustration with judicial rulings never excuses a lawyer while acting on their own behalf from abiding by a court order. And the history of this case, as I'm sure if you've reviewed any of it, Your Honor, is that Ms. Burke consistently violates the gag and seal orders in this matter. And that is the direct proximate cause of her current status, the current status with her license. We are also very concerned with regard to the fact that Ms. Burke is currently live streaming this on YouTube. She has set up a live stream, and at present, Ms. Burke is live streaming everything that is going on in this matter, and so on YouTube. We have been listening to it this morning, and I can show the court right now. This is Ms. Burke's live stream that is on YouTube. And there is no way for the court, in our opinion, without having us together, there's no way to stop Ms. Burke. She has repeatedly violated orders. She has been sanctioned by the state bar because she was ordered to not live stream or record proceedings, and she immediately posted them on Facebook as well as on YouTube after the conclusion of hearings that she was specifically ordered to not record or disseminate. And as pursuant to your minute entry, you, with regard to scheduling of a hearing, Ms. Burke's, this hearing remains gagged and sealed. The entire case is sealed, and Ms. Burke is not to disseminate any information regarding this matter.
All right, thank you. Ms. Burke, are you live streaming this hearing right now?
Yes, Your Honor.
And why is that?
Because this entire matter, the whole reason we're homeless and cannot file and cannot speak is due to 8 years of First Amendment retaliation by Ms. Paul and Mr. Contreras to cover up Mr. Contreras's domestic violence and corruption of the court. So there's been actually no order regarding live streaming, and I'm doing so under my Rule 122H right, and it's an absolute right, and there's been no motion to close this hearing. There's been no seal of the quote entire case. There's the gags. If Ms. Paul wants to again argue the gags, she's constantly publishing everything that happens in this case to take my license to practice away. She was the one who disclosed everything to the state bar. She pushed that case, did not allow me to access witnesses, and to this day stands behind the fact that they can publish anything in this matter as long as it takes away income, resources, and hurts our child.
Okay, so ma'am, I have looked at the Supreme Court Rule H.
Yes.
122H, and it indicates the person using a personal audio recording proceeding must notify the judge or the staff prior to using such a device unless
Yes,
it's a
sir.
personal audio recorder, which I believe live stream does not count as a personal audio recorder. It's not like it's just on you.
It's on me.
It's on you?
Yes, Your Honor.
Where?
I can show the court my phone. It's right here. And I made sure that I had the mute function readily available so that if anything out of 122H applies, I can instantly hit mute. You know, that applies only when the court goes off the bench or for some reason there's an approach to the bench and there's an attorney bench conference.
All right, so ma'am, I'm going to order that you turn off the live stream immediately. There are multiple gag orders in this case. I had previously issued an in-chambers order indicating that this will be a closed hearing for the various reasons is that this case has been ongoing so long and has been litigated in various matters. The court does find it appropriate not to be live streaming at this time. So in order that you turn off the live stream.
I'm going to decline that, Your Honor. There is no such order closing it. There's been no request to close this hearing. The 4D matter was never subject to a seal, a gag, or anything else. And the only thing that's going to protect my son and me is actually having some accountability for petitioner here. He's been hiding behind one-way gags, one-way seals, and he's never produced any. And I'm going to decline the order to not actually exercise my Supreme Court right under Rule 122H.
And I'm going to give you the option of appearing by conference call. You'll be able to participate in the proceedings, but you'll not be able to, if I kick you out of this virtual hearing, but appear by conference call, you'll not be able to stream anymore. I suppose you could stream the audio only.
That is what I'm
gonna give
doing,
you
Your
one more
Honor.
chance.
I'm not streaming the Zoom proceedings. I'm only doing audio. I notified Ms. Bond of my 122H invocation a few days ago. Again, every time it gets pushed back, I do that. And I notified her a couple days ago. It is only the audio portion that is being live streamed.
And Your Honor, again, we would assert that 100% of everything that goes on in this matter, as the history of this case, is sealed. And that includes any of the audio recordings. And we would request that the hearing be terminated until such time as Ms. Burke complies with the orders of the court. And Your Honor, you did issue an in chambers on April 17th that stated that this hearing will remain closed to the public as previously issued gag order in this matter still remains in full force, or remains in effect and applies equally to all parties. And dissemination of the audio is a violation of the gag orders, Your Honor.
There's no such order, Your Honor. There's no such order.
I issued that order on April 17th now, a couple of weeks ago.
Right. Well,
Unfortunately,
the way Ms. Paul is
So,
stating it is
ma'am,
that you relied on a previous
Burke?
order that does not exist.
It currently does exist, and as of last year, there were prior orders from Judge Wade as well that it still existed. So I'm going to ask you one more time. Please stop live streaming, even though it's just audio. Please stop live streaming so we can continue with this hearing. If not, we'll terminate this hearing. We'll have to reschedule it in person such that you cannot record. We'll make sure that phones can be taken away with court security present. So I'm going to ask you one more time, ma'am. If you want to go forward today, you have to stop live streaming.
It's under 122H, Your Honor. It has nothing to do with the non-existent one-way seals and gags. If that were true, Ms. Paul and Mr. Contreras wouldn't constantly publish everything to the state bar to keep me unable to work. They're constantly doing that. So if they were actually in place, they would be both ways. They do not exist, and they do not exist for purposes of any 4D hearings, any child support hearings. The last known sealing, closing, gag order was with regard to Mr. Contreras's request in late December 2022, and it was restricted to child support, or I'm sorry, legal decision-making and parenting time only. That is the only one that's in effect. That is it, that I know of. And I
Mr.
specifically,
Simons, do you have a position from the AG's office regarding the gag order?
That, to me, that seems ancillary to any child support obligation, so the AG will be taking a position.
I understand, ma'am, that you're asserting your Rule 122 rights under the Arizona Supreme Court.
Yes.
However, there are other orders that are conflicting right now, and those rules orders take precedence, and more specifically, my order that I issued a couple of weeks ago. So I'm going to ask you one more time. If you do not agree to stop the live stream, we will terminate this proceeding, and we will reschedule this in person at a point where you will not be able to live stream with a personal device on your person.
Your Honor, could I have the order that you're referencing so that I can make
April
a
17th,
more informed
26th.
decision? Right. Well, the one that you're referencing within that, you're referring back, Judge Wade referred back, and I have asked many times, where's the one-way order? And there's no such order regarding 122H, but anyway, so I can make an informed decision as to whether I can protect my child in this matter. I'd like to know what the backwards references are, because I keep seeing pursuant to prior orders, and I know that those don't exist.
Your Honor, the most recent order that covers the child support, if that is what Ms. Burke is referring to, was issued by Judge Assini on November 5th of 2021. In paragraph 3 of that ruling, it says the court ordered closure is limited to the current issues that are in front of the court, that being the modification of legal decision-making, parenting time, and child support. So child support remains an issue in this matter that is sealed and closed. Further, on March 4th, 2025, Your Honor, Judge Wade, one of the orders I believe you were referring to, Your Honor, it says the last paragraph in that order on March 4th of 2025, the court affirms that all previously issued gag, seal, and closure orders within the scope of this docket number remain in effect and apply equally to both parties. With regard to Ms. Burke's allegation that information is published to the state bar, I have contacted ethics counsel. I am ethically required to report any conduct that I believe is a detriment to the public. And every single time that I have submitted any of the rulings in this matter or documents that Ms. Burke has filed that are in violation of the rules of ethics under the rules of ethics for practicing attorneys in the state of Arizona, every single time I have requested that all of those documents remain under seal, which is what is required. And so my ethical obligation, according to ethics counsel with the state bar, is to ensure the integrity of the profession, which means that when Ms. Burke does things that are unethical, the state bar needs to be aware. However, the current status of her licensure is terminated or is suspended because she repeatedly has violated court orders, which is contrary to, it's prejudicial to the administration of justice, and it's a violation of Rule 54C, which is a knowingly violation of any rule or any order of the court. So those are, I mean, I have an entire history of the gag and seal orders. I don't have it, but the gag and seal orders, and they have also been affirmed by the Court of Appeals as well.
All right, understood. The court takes judicial notice of the undervisement ruling from Judge Assini from November 5th, 2021, which includes, as Ms. Paul indicated, the gag and seal order applies to child support matters.
Currently
as well as
under review at that time.
the August 1st, 23 order from Judge Assini affirming that both parties had apparently violated at that period. Also, Judge Wade from March 4th, 25, affirming prior gag seal orders, and Judge Wade from December 31st, 2025, affirming gag seal orders, and again, my order from a couple of weeks ago, April 17th. So, ma'am, one more time, do you want to go forward with this hearing, or are you going to continue to live stream?
My Rule 122H right is absolute. It has nothing to do with any gag or seal orders, and those were for 2022, a hearing that was resolved by early 2023. And in fact, I think the state even mentioned that it thought my child deserved no child support from back in 2018 when I first requested this hearing because that was long over with. So the only reason that Mr. Contreras wants everything covered up is because he does not want to support his child. He wants us to remain homeless. And he wants to take the child like he already did.
Sure.
And he wants to keep it covered up.
All right, thank you, Ms. Burke. I'm going to order that if you want to continue streaming at the next hearing, that you will have to file a request with the court why you believe that 122H applies and does supersede any prior. Well, I did not receive a copy. Make sure I get a copy of it, please. And we're going to terminate the hearing at this point as Ms. Burke is not cooperating with the court's orders regarding prior gag seal orders, the live streaming, or does not find it appropriate to go forward with.
Can the court reduce that to some kind of special actionable writing so that I can immediately issue a special action or
that request is denied. It's not a final order for special action purposes. All right, we're going to be. Court's going to reschedule this in person, and meanwhile, while we reschedule this in person, ma'am, you can file that request while you believe that 122 supersedes.
I did. I already did. I can give you a copy right now. Ms. Bond has it multiple times over, as per the rule.
Okay. Well, if it was filed, I would have gotten a copy of it.
Your Honor won't let me file. No one will let me file. That is a big issue here, and that is why I need the protection
Well,
of being
I'll
able.
let Judge Wade know that I allowed you to file this one request so that he can see it first before he allows the vexatious litigant to file. So, all right, we are adjourned. I do apologize that we can't go forward today, but this is a very big matter and significant. And I do find it's not appropriate with the gag order in place to be live streaming.
There's no gag order in place for this hearing, Your Honor.
All right, we're adjourned. Thank you, everyone. Apologize for
Your
the
Honor, if
inconvenience.
I might make
Yes,
one
Mr. Simmons.
comment.
Yes.
I understand we'll probably have this hearing in Cochise County in person.
Yes.
I'm based in Tucson. I believe Ms. Paul is also. If we could schedule the hearing not before about 10-ish, just to make commuting a little easier. That
Around
would
10
be
a.m. Okay.
yeah, rather than earlier, as there's a substantial commute.
Okay. I'm also, of course, based out of Tucson, out of Pima County. So,
And we're homeless still, Your Honor, because no one will pay child support and no one will allow me to work. So I would like my schedule accommodated as well, which is something I tried to do. And Ms. Baum will not let me even communicate about my schedule. I am homeless. My child, his child, Judge Contreras' child, is homeless. Please
all right.
also
Regarding
ask
that,
about
Ms.
my
Burke,
schedule.
Judge Wade has already made findings regarding your living situation. I believe he found earlier.
No, he actually has not, Your Honor. He will not address best interests. He refuses to, as this court is refusing
Thank you.
to. Okay, so I just don't even know. I need a break from this. I need to walk away. Which is the corruption is so deep and so vast. This is absolutely batshit insane that this Judge Deadbeat gets away with this for 8 years now. I try to do the minimal protections, which I'm allowed to do by law and in the law of this case. Still nothing. I need a break. Thanks for joining those who did. Thank you for joining. I need a break.